Counsel, did I misunderstand your argument? I thought one of the areas of daylight was that you thought it would apply even when circuit precedent changed, as opposed to just when Supreme Court precedent changed. Did I misunderstand that?
Sorry, Your Honor. I was just referring to the comparator in the government that the government is proposing to the traditional habeas relief and the bench line. There are two disagreements between us and the government, Your Honor, which are very important. One is that, under our view, a change in circuit precedent, as you've identified, Justice Barrett, should count for these purposes. We believe that they've misconstrued Davis versus United States. In that case, Your Honor, the change of law by this court, the Gutknecht case, happened while the Davis case was on direct appeal in the Ninth Circuit. And then the Ninth Circuit remanded the case to the district court, and the case came back up again. And it's impossible for Gutknecht to have represented the change in law that was relevant there because it changed before the direct proceedings were concluded. The change in law that this court itself identified was a change in law of the Ninth Circuit in the Fox case, which later interpreted Gutknecht, Your Honor.
How do you propose to handle some of the choice of law problems that changes your theory that circuit precedent changes create?
And there are arguments on both sides, Your Honor, which you identified in your Chazen opinion while you were sitting on the Seventh Circuit. In our view, the view that you gestured at is actually the correct one, that the court should apply the law of the sentencing circuit rather than its own. And I know that is, in some sense, an anomaly, but it's not a complete anomaly in our system. For example, the Federal Circuit, I believe, now applies the law of the circuit to supplemental non-patent claims in cases that are before it. So this would be no stranger than that kind of thing. And certainly, the Federal Circuit has not been authorized by Congress to do that. It's a rule that it has developed under Federal Circuit common law. The other big difference between the government's view, Your Honor, and ours concerns the actual innocence test. The government says that actual innocence should be a gateway doctrine regulating everything that goes through 2255E. Interestingly, though, all the support the government has cited for that, Schlupp, McQuiggan, Bowsley, and Kuhlman, all concern abuse of the writ doctrine. And it's our contention that the actual innocence test is one way of getting over the abuse of the writ doctrine in a 2241 proceeding or 2255 proceeding when it is raised by the government. But it is not the only way and should not be created at or placed at the 2255 gateway to 2241 as an absolute and singular requirement. We believe that the traditional other gateways, like cause and prejudice for procedural default, should be available too. And we believe that our client actually would satisfy the procedural default standard here, and if not, could actually establish actual innocence. But that should be a matter on remand from this court.